So today I'll be talking about innovation and transparency for reliable forensic software. Thank you for inviting me. I'm going to focus on a case that involved source code requests, California versus Martell Chubbs. In 1977, a 17-year-old Long Beach mother was found raped and murdered in her home. Her toddler girl was at her feet. Years later, on a cold case project in 2011, a DNA lab tested the vaginal swabs and found a three-person mixture, victim, elimination, and unknown. And the next year, the major sperm fraction profile was found to match Martell Chubbs with a manual method statistic, combined probability of inclusion, or CPI, of 1 in 10,000. And the next year, our company, Cybergenetics, using our TrueAllele probabilistic genotyping technology, found a likelihood ratio statistic to Chubbs of over a quintillion. That's a 1 followed by 18 zeros. The lawyers for Chubbs approached the DNA in an interesting way. It was hard to attack the reliability. The software was extensively validated as probabilistic genotyping software. We'd already had a Kelly Fry hearing in California. And so the question tactically is, how do you suppress incriminatory DNA evidence? And the approach that was taken is to, from my perspective, to demand irrelevant trade secrets that a company can't release. And that's the source code gambit. Hire an expert, falsely claim that source codes needed to assess software reliability. What's source code? Well, we begin with an algorithm, looking on the left here. It's a procedure for solving a problem. And a programmer writes computer instructions called source code in a human-readable computer language that, on the last step, a computer compiler can translate into a software application. That's what users have. That's what's tested. Input goes in, output comes out, and that's what's in the real world. Algorithms can be patented. They're published. We publish our algorithms. Patents have not been great for protecting algorithms recently, given the Alice decision from about 10 years ago. And so that leaves trade secrets, which is not disclosing proprietary information. And that's generally source code for commercial software is a trade secret. But the software application is released, and that's what can be tested and assessed. How do scientists assess scientific reliability? Science, almost by its definition for the last 350 years, is the empirical testing of hypotheses. That's what science means, and that's what makes science different from other fields, like law or politics or religion. There are national standards and guidelines for testing probabilistic genotyping software, called PGS sometimes. And the computer source code is entirely irrelevant to this scientific testing, to national standards or admissibility standards. You take your software, you put data into it, and then you run it and you see what comes out. That is true for the software, the robots, any machines, the chemistries. That's how science works. And Cybergenetics makes the software available as an application program for free for testing by defense experts. We make many other things available as well, but by making the application available, that's the height of transparency. There have been at least 42 written up validation studies where TrueAllele has been tested. 8 of them have been published in peer-reviewed journals, which is the scientific and Daubert standard for having the community give an anonymous assessment, an independent assessment of the reliability of a technology. Another way of testing software is to run other programs that are similar, other PGS programs or methods on the same Chubbs data in the case. And that was done. 9 programs, whether it's the simple CPI methods or the open source methods where anybody can look at the source code and see what's going on, LRMix, Lab Retriever, like LTD, all of these programs pretty much, they gave the same answer. Chubbs was included. With simple software that made less use of the data, the answer might only have been in the thousands or billions. With more sophisticated software that could fully engage the quantitative data, the answers were in the quadrillions or quintillions, 16 or 18 zeros. TrueAllele has a broad community that relies on the results for post-conviction. We've helped 10 exonerations of innocent men. There have been almost 250 defense cases we've worked on, including acquittals that were directly attributable to the use of better forensic science of TrueAllele. Our crime labs have solved tens of thousands of criminal cases. We worked on the World Trade Center disaster, helping to identify 18,000 victim remains, and scientists who study DNA publish papers where they use TrueAllele as a way of objectively and accurately measuring DNA information from samples and mixtures. And there are other applications as well. The Chubbs appellate decision had three main points addressing what the defense had appealed on. First is the trade secret privilege. The court said that the defense requires a prima facie particularized showing that the source code is relevant and necessary. That didn't happen. They opined on the necessity of source code in their unpublished opinion. They said Chubbs has not demonstrated how TrueAllele's source code is necessary to his ability to test the reliability of its results. And they addressed the confrontation clause as being premature in the case. And in 2016, Chubbs pleaded no contest to the homicide charges and was sentenced to 7 years and 8 months in prison. Over 20 courts have ruled on source code. And on the left, I'm showing you cases where there was a hearing with expert testimony. On the right, where there was no hearing or expert testimony, it was just done on the papers. This started in 2009 with the Foley case. It's continued today. In fact, a few months ago at the bottom, the left column is Pennsylvania versus Sputis. In blue, those are the cases where the courts have ruled that the defense is not entitled to source code, mainly because they can test the program scientifically on data like real scientists do. There was an interesting result that we may be talking about more today that was very aberrant. There was no hearing, expert testimony. The facts were completely incorrect. And that was New Jersey versus Corey Pickett. That's another case I'm involved in where the judge just adopted the Pickett decision without much further ado. I do want to stress that under suitable protective orders, Cybergenetics has indeed provided its TrueAllele source code to defendants. We don't think it's useful for anything, but if asked and it's important for the case to continue, we will. Now, the source code Gambit basically feeds on false facts. In California versus Chubbs, the expert wrote, access to this code is the only way to fully consider the validity of the software. The court did not agree. In New Jersey versus Pickett, the court said many things that were strange, including that source code access would allow an expert to independently test whether the software works as intended. One of my PhDs is in computer science, and that's not a true statement. I don't know where it comes from. You test application software. You don't test source code. It's not going to answer that question. And these myths are picked up by academics and propagated. There's a law professor who wrote a Harvard Data Science Review article where in his one sentence that mentioned TrueAllele, there were 3 statements that were incorrect. It's not the case that TrueAllele and StarMix were excluded by the court. Only StarMix was. TrueAllele wasn't even in evidence. The FBI did not develop StarMix. And in fact, as I've written and published on this, StarMix reached 2 contradictory results itself. TrueAllele agreed with one result and disagreed with the other. So these statements don't make much sense. But that's what courts end up picking up on, these urban myths and false facts. The way the Gambit actually works is escalating demands. First, they ask if they can read the source code. The judge orders it, we give it to them. They're not happy. Then they get electronic source code. They ask for more. Of course, we're concerned, what if they lose it on the internet? Then they ask to run it, and then they ask to build it. The most recent requests that have been denied by courts is they want to rebuild the entire software system themselves, redoing a 10 or 20-year development effort. Nowhere do they mention testing the software application, which is how real scientists assess reliability. So the goals are mainly to suppress scientific evidence in a case, and more largely as a national effort to eliminate forensic science innovation. But the impact would be to block scientific truth, which in my view leads to injustice. I have a lot of experience seeing that. And there's another goal that I sense in many of the amicus briefs, which is to eliminate trade secret protection for all software. In light of the minimal patent protection after the Alice decision, I would say trade secrets is what we have left, and the impact on reducing Silicon Valley and America's competitiveness in the software industry is not good for the country. So in conclusion, science and law has reliability based on empirical testing. Source code doesn't provide empirical testing. These discovery demands are irrelevant to reliability. They're destructive to innovation. And real transparency requires software testing access, which is given by private companies. And trade secrets are not material and can ruin companies. Thank you very much.